I selected this one for my subscribers, as we get to see what it looks like when the lawyer fires the client, and you actually see the disgust in the client that the lawyer has. It's funny. Enjoy.
I picked this clip for you because it shows something rare. A lawyer walking away from a client, and the frustration is visible on both sides. Buckle up. On-screen text, lawyer quits. Watch the drama. Reaction note. Open with energy. Set expectation that this is both dramatic and instructive. Audience question. Ever seen a lawyer fire a client? Tell us below.
For a continued bond hearing, and the court ordered on that date that the jail would arrange for Mr. Watson to have a psychological evaluation by January 21st.
I don't know, Judge. He indicates that he had a doctor, a psychologist, a psychiatrist come and interview him in the jail. If they did not send you a report, I just don't have any control over it.
I don't have a report.
Yeah.
This hearing started as a routine bond check. The court had ordered a psychological evaluation for Mr. Watson, but right away we can tell paperwork and reports are missing. The defense says a psych was in the jail, but nobody sent a report. On-screen text, missing report, shocks red flag, reaction. Point out the bureaucratic friction. This is important because missing documents can change the judge's decisions. Transition. Let's watch how this paperwork gap fuels the next moments.
And I would also indicate that my notes reflect that Mr. Watson's sister was anticipated to join us. I don't see anyone on Zoom. Mr. Watson, sir, do you know whether your sister was intending to join us today?
Sister, she's at work. She's worked from 7 to 7. She said she said I can come on to her house. She said you able to call her. She says you able to call her whenever you at the hours of 7 o'clock, 7 p.m. We have a new company. She said she would love to come.
One moment, Mr. Watson. Mr. Watson, about what time do you think your sister would be taking
My sister
a break?
said she worked from
Mr. Watson, I heard that. I need you to listen to my question, okay?
Now the judge asks about Mr. Watson's sister. The court expected her on Zoom. She's not there. Mr. Watson says she's at work. The judge presses him. When can she break to join the call? On-screen text. Court needs witness. Sister MIA. Reaction. Highlight the awkward back and forth. The judge is trying to balance fairness with procedure. Audience question. If a family witness can't attend, should the hearing be postponed?
What time do you think your sister would be breaking while she's at work? Because she has to have a break.
She can break. She worked 5 days a week. She's through a new company. That's what I'm saying. It's my sister. She said, what is the problem? Because I'm gonna be on teller and y'all gonna know my location. She can't leave she can't leave her facility. She just started this new company. And she said she would love
Mr. Watson, I'm gonna ask once more. At what time do you think your sister will take a break?
I don't know if she said
I'm still talking. Everyone who works gets a break. That's the law. So we can find out what time she takes a break so that we can get her on the phone or get her on Zoom. Because if the court is not able to...
The judge makes it clear, if she won't talk to the court, he won't move forward with release. He's not promising release. He just needs to speak with her to decide. On-screen text. Judge, I need to speak with her. Reaction. Emphasize the judge's carefulness. It's not personal. It's responsibility. Transition. This is a good example of how judges seek certainty before granting freedom.
To speak to her, I may as well just cancel this hearing. There's no way that I'm going to even consider releasing you if I haven't been able to speak to her. And I want to be very certain. I'm not saying that I'm going to release you. But for me to make a determination whether to release you, I need to speak to her.
You can try to call her right now. I don't even know her break, but I'm trying to figure out what is the problem. This don't even make no sense to me.
Mr. Watson, I think what you're saying is because you don't understand why I'm telling you I need something that I shouldn't need it. I think it would be better for you to stop talking.
Just for informational purposes, Judge. I was able to talk to his sister, and his sister indicates that she's
Update, the sister does confirm she'll have him live with her, but she won't post bond or be financially responsible. The judge says that's fine, but if he's released, she must agree to report any bond violations. On-screen text? House? Not bond, sister won't pay. Reaction? Call out the practical trade-off. A place to live helps. But the court also wants oversight. Audience question: would you report a relative if they were on bond and living with you?
very happy to have him living with her, but that she's not going to be responsible for the bond. She's not putting anything toward the bond, but he's certainly welcome to come and live with her.
Well, I'm happy to know that, but if I were to grant Mr. Watson bond, at the very least, I would be requiring his sister to agree to report any violations of the conditions of his bond. So the bond is going to remain the same until I can speak with Mrs. Sister.
She doesn't have a bunch.
Officer, about the psychological.
Yes, nurse long over at sorry, first.
Yes,
Said he spoke on the 19th with Dr. Hayes, the psychiatrist.
Dr. Hayes.
Hayes.
And-
And I'll have, if you want a copy of that.
I do need a copy. So I'm sorry, what date was that he was evaluated?
It's a January 19th.
How long do you think?
There's also the psychiatric report. The court learns Mr. Watson spoke with Dr. Hayes on the 19th. The defense asks for a copy, and the judge says they'll go off the record briefly to sort the timing. On-screen text. Psych report, key evidence. Reaction. Point out the importance. Mental health evaluations often influence bond and conditions. Transition. But then things get personal between the lawyer and client.
It would take for us to get a copy of the report. So what we'll do is we'll go off the record and wait for the date. Just one moment.
Judge, before we do that, could I be heard?
Yes.
I and Mr. Watson simply cannot work together. I don't want to go into all of the specifics, but he sees Miss Scott and I talking, and he says, y'all are working something. Today, it's even more than y'all are working something. It's I'm working for her. I can't continue to hear that kind of complaint. And there's so many more complaints. Mr. Watson and I cannot work together. There's a breakdown. We're never gonna be well with each other.
Well, you've been practicing long enough to know whether that's the case, Mr. Cooper. And so, on your word that there's been a breakdown between you and Mr. Watson, I have no choice but to release you and appoint new counsel for Mr. Watson. Mr. Watson, that is very likely going to delay your trial, which is scheduled for March 17th, because your new attorney will need enough time to prepare for your trial. So, and I need to have a trial date in mind.
The judge warns Mr. Watson replacing counsel will likely delay the trial, originally set for March 17th. He keeps that date as a pre-trial and orders that someone be appointed quickly so the new lawyer can prepare. On-screen text, delay likely, trial prep needed. Reaction, explain the stakes simply. Switching lawyers isn't just drama. It affects time, preparation, and strategy. Transition. And Mr. Watson's reaction tells us more about the strain in the room.
As part of my bond consideration. So this is what we're going to do. We're going to keep the March 17th trial date, although Ms. Scott, it won't be a trial date. It will be a pre-trial, so that we can get someone appointed to Mr. Watson. And we really need to have someone appointed before March 17th, though, now that I'm thinking about it. We'll keep the March 17th date as a pre-trial date, but we're going to get Mr. Watson appointed counsel sooner than that. We'll work on that off the record. And we'll contact everyone and let you know when we have someone so that we can bring that person in immediately for
Can I say
a
something? Your Honor?
calendar conference. No, sir. And it's really not in your interest to do so without counsel.
Keep an eye on how many times the lawyer makes a gumption to leave.
I didn't even. That's crazy, man. Y'all just
See, this is what I'm
roll
saying.
somebody because
This is
I
what I'm
didn't
saying.
call my
Now
security.
what you're doing, Mr. Watson,
That's
is
crazy.
you're flirting with.
We're not done here. Until the judge says we're done.
Mr. Watson protests loudly, claims he followed instructions, and accuses people of lying. The judge repeatedly tells him to stop talking. Near the end, an officer notes the defendant may not be taking medication. That detail could explain some behavior and is exactly why courts need thorough records. On-screen text. Medication? Important context. Professional overview. Short. Bottom line. The hearing shows multiple system failures, missing reports, a key witness who initially couldn't join, and a defense breakdown that forces new counsel. The court acted cautiously. It kept the pretrial date, required follow-up on the psych report, and appointed new counsel to protect Mr. Watson's right to effective representation. Broader implication. This clip is a reminder that procedure matters. Paperwork, witness availability, and mental health info all shape outcomes as much as the alleged charges do. Final CTA, VO Plus on screen. If this breakdown shocked you, hit like, drop your opinion in the comments. Who's at fault here? Subscribe for more courtroom clips and legal breakdowns. Welcome to the channel. On-screen text, like, comment, subscribe.